Good day. This is part one of the three-part video on the law on self-proprietorship, partnership, and private corporation. Understanding the legal framework that governs business entities is crucial for aspiring entrepreneurs and business professionals. In the world of commerce, businesses can take on various legal forms, each with its own set of rules, advantages, and limitations. So, in this session, we will delve into three primary categories of business entities in the Philippines: sole proprietorship, partnership, and private corporation. We will explore each business entity type's distinct characteristics, formation procedures, management, taxation, liability, and regulatory requirements. This knowledge will empower you to make informed decisions about which business structure aligns best with your entrepreneurial ambitions and strategic goals. At the end of this session, it is hoped that you will gain valuable insights into the diverse options available for organizing and operating businesses within the legal framework of our jurisdiction. Specifically, you will be able to discuss and differentiate the different types of business entities, identify the requirements for forming and dissolving sole proprietorships, partnerships, and corporations, and differentiate each. So there are three forms of business entities. These are these three categories represent the spectrum of business structures ranging from the simplest and most straightforward to the most complex and versatile. Whether you plan to start a small enterprise, collaborate with others in a partnership, or establish a large scale corporation, you'll need to navigate the legal landscape underpinning these business forms. So, as to sole proprietorship, a specific law does not govern sole proprietorships in the Philippines. Instead, they are subject to general business laws and regulations, including those related to business permits, licenses, taxation, and other relevant local and national regulations. The specific legal requirements and obligations for sole proprietors can vary depending on the nature of the business and its location. For partnerships in the Philippines are governed by the provisions of the Civil Code of the Philippines, particularly Articles 1767 to 1867. These are of the Civil Code. So these articles outline the rules and regulations related to forming, managing, and dissolving partnerships. Partnerships may also be registered with the Securities and Exchange Commission under the Corporation Code of the Philippines if the partners choose to do so for added legal protection and tax benefits. Then the third form is corporation. So entrepreneurs in the Philippines should be familiar with the Corporation Code as it governs the establishment, management, and operation of private corporations in the country. This revised code, the Republic Act number 11232, or the Revised Corporation Code, introduced several significant changes to corporate governance and regulatory frameworks. Uh, Corporate governance and regulations. So let's discuss sole proprietorship. Under Philippine law, a sole proprietorship is a business structure where a single individual or the proprietor or owner owns and operates a business as a single person entity. This is one of the simplest and most common forms of business organization in the country. Here is how a sole proprietorship is defined and characterized under Philippine law. So, single ownership means in a sole proprietorship, a single owner has complete control over the business's operations and decision making. This individual is personally responsible for all aspects of the business. And then there's no legal distinction. Unlike corporations or partnerships, a sole proprietorship does not have a separate legal personality from its owner. This means that the owner and the business are considered one and the same in the eyes of the law. In terms of personal liability, The owner of a sole proprietorship is personally and unlimitedly liable for all the business debts and obligations and liabilities. This includes using personal assets to settle business debts if necessary. Regarding business name registration, to operate a sole proprietorship in the Philippines, the owner must register a business name with the Department of Trade and Industry or DTI. This registration helps distinguish the business from other sole proprietorships and provides some legal protection for the business name. For business permits and licenses, depending on the nature of the business, the owner may need to obtain various permits and licenses at the local and national levels to operate legally. Compliance with tax regulations and other regulatory requirements is essential. Examples of additional permits and licenses that restaurants and hotels should secure aside from business permits and BIR registration are health and sanitary permit, and, fire inspection certificate. Then, ayun, if you plan to serve alcoholic beverages at your restaurant or hotel, you must obtain a liquor license from the local government or the Philippine Alcohol Regulation Commission. If your establishment has the potential to impact the environment, you may need an ECC or environmental compliance certificate. And then for food establishment permit is a must to ensure that you operate a legitimate food service establishment that complies with safety regulations. And then occupancy permit for hotels, an occupancy permit is often required to ensure that the building complies with safety and structural standards. Then also, if you have a trademark, then you must register it with the IPO, the Intellectual Property Office. And of course, accreditation from the Department of Tourism. Hotels and resorts may seek accreditation from the DOT, which can be beneficial for marketing purposes, yun, for promotion, and attracting tourists. Okay. So we move on to the next characteristic, as to taxation. In a sole proprietorship, the income generated by the business is considered the owner's personal income. So by that, the owner is responsible for reporting and paying income taxes on the business earnings. A sole proprietorship may exist for as long as the owner wishes to operate the business. Starting and dissolving a sole proprietorship is relatively easy. This is one of the benefit of this uh, particular form of business, as it does not involve complex legal processes. As to capitalization, the capital used to start and operate the business is typically provided by the owner, although additional capital may be obtained through loans and other means. In terms of control and decision making, the owner has full control over the business operations, including decisions related to product offerings, pricing, hiring, and strategic planning. Then ownership transfer, it's relatively straightforward to transfer or sell a sole proprietorship, but the process typically involves the sale of assets and assignment of contracts rather than the transfer of ownership in the same way as in corporations or partnerships. So that is just the sole proprietorship. Let's now discuss partnership. So, our partnership law is governed by the Civil Code of the Philippines, specifically under Title 9, which covers partnership and its different aspects. For future entrepreneurs like you considering forming a partnership in the Philippines, you should be aware of the following salient features and key considerations. First, a partnership is defined as a contract where two or more persons bind themselves to contribute money, property, or industry to a common fund to divide the profits among themselves. So that's Article 1767. So this definition does not include religious associations, conjugal partnerships, and other of similar nature because a partnership, as defined by law, refers only to associations the purpose of which is to obtain profits to be distributed among the partners. This contract is based on trust and confidence. So, partnership contract is based on trust and confidence. Hence, no one can become a partner in a partnership without the consent of all the partners. So, there are two tests based on the definition. There are two tests to determine the existence of a partnership. First, determine whether or not there is an agreement to contribute money, property, or industry to a common fund. And second, determine whether or not the contracting parties intend to divide the profits among themselves. So, a partnership can be classified in terms of subject matter, liability, and duration. According to subject matter, it uh, according to subject matter classifies partnership into universal or particular. When we say universal partnership means all the partners contribute all of their properties to the common fund and speak of no particular purpose or subject matter, as long as the purpose of forming a partnership is to obtain profits and is not contrary to law, morals, public order, public policy. But today, businesses seldom form this universal partnership. On the other hand, a particular partnership has for its object determinate things, their use, or a specific undertaking, or the exercise of a profession or a vocation, like a law firm established by lawyers, a consultancy business, or a restaurant, ayan, or a consultancy business. Ayan. According to liability, partnership is classified into general or limited. General partnership is composed of general partners where liabilities extend to their personal properties, while limited partnership, which usually attaches the word limited or LTD at the end of the company name, is formed by two or more persons having as members one or more general partners and one or more limited partners, where the liability of the limited partner to third persons is limited to their capital contribution. So yeah. So unlike general partner whose liability extends to their personal property, a limited partner will only be liable up to the amount of his capital contribution. Then as to duration, there is partnership for a fixed term, one in which the term of its existence has been agreed upon expressly. So there is a definite period, or impliedly, as when a particular enterprise or transaction is undertaken. The expiration of the term thus fixed or the accomplishment of the particular undertaking specified will cause the automatic dissolution of the partnership. For example, two established caterers who have been, let's say, friends since their college days as hospitality management students formed a partnership to establish a catering business called let's say URAC event. However, they are both approaching retirement age and do not plan to be in the catering business indefinitely. So instead, they just want to collaborate for a fixed period of time, say 5 years, after which they will retire and dissolve the partnership. So at the end of 5 years, the partnership automatically, so at the end of 5 years, the partnership is automatically dissolved, or or they can negotiate a renewal of the partnership agreement. So also as to legal personality, a partnership does not have a separate legal personality distinct from its partners. So this means that partners are personally and jointly liable for the debts and obligations of the partnership. Personal assets can be used to satisfy partnership debt. Formation and registration partnerships may be formed orally or in writing. However, it is advisable to have a written partnership agreement that outlines the terms and conditions of the partnership. Partnerships can also be registered, as I've mentioned, with the Securities and Exchange Commission for added legal protection and benefits. So, unless the partnership agreement specifies otherwise, each partner has equal management rights. So, in terms of management and decision making, equal management rights and responsibilities, a majority vote of the partners generally makes decisions, but significant decisions may require the unanimous consent of all partners. Then, profit and loss sharing. Profits and losses are typically shared among partners according to the terms of the partnership agreement. Without an agreement, uh, profit and losses profit and losses are shared equally among the partners. As to capital contribution, partners are required to contribute capital to the partnership as specified in the partnership agreement. Failure to do so may result in the expulsion of the non contributing partner or other remedies as outlined in the agreement. Then limited partnership, in addition to general partnerships, the Philippines also recognizes limited partnerships where some partners can have limited liability. So limited partners are only liable up to the extent of their capital contributions, while general partners remain personally liable. And limited partners have limited liability, which means their personal assets are generally protected from the partnership's debts and obligations. But limited partners typically do not have a significant role in the day to day management or operation of the partnership. They are passive investors who provide capital or assets to the partnership but do not participate in the managing of its affairs. Then, partnerships in the Philippines are generally not subject to income tax at the entity level. Instead, profits are taxed as part of the individual income of the partners. So, partnerships may also be eligible for certain tax incentives or exemptions depending on their industry and activities. As to dissolution and liquidation, partnerships can be dissolved for various reasons, including the expiration of the partnership term, death of a partner, insolvency, or by mutual agreement. After dissolution, the partnership's assets are liquidated and creditors are paid before any remaining assets are distributed among partners. So, partnerships are often established for a specific period or purpose, so limited life, and they typically have a limited life. However, they can be renewed or extended if they can be renewed or extended if the partners, of course, agree to it. So, partnership forms, there are three considerations if a contract of partnership should be oral or written. So, generally, partnership can be any form, even if not recorded before the Securities and Exchange Commission, except when it is stipulated. So, the parties agree that it should be in another form, it should be in writing. When immovable property or real rights are contributed, in which case there must be a public instrument as required by law. So, to which you need to attach an inventory of the immovable properties signed by the parties. Otherwise, the partnership is void. However, in the case of limited partnership, the parties must sign and swear to a certificate which shall state, among others, the name of the partnership, adding the word limited and the character of the business. So this is a special requirement for limited partnership. And then you need to file the partnership agreement for record this file for record the certificate in the office of the Securities and Exchange Commission. Take note that failure to comply with any of the formal requisites for limited partnership, that's the one in number three, does not make the partnership contract void. It will only make the partnership a general partnership. Then, as to obligations of the partners, so it is important to note the partner's obligations when entering into a partnership contract. Take note that partners may be capitalist or industrial. Meron din tayo kanina general and limited. So this one now is a capitalist or an industrial partner. A capitalist partner contributes money or property or both money and property to the common fund, while an industrial partner contributes only their industry or labor to the common fund. So the obligations of the partners are typically, in summary, parang there are eight across the provisions of the civil code. So where contribution is money or property, if a partner promises to contribute money during the celebration of the contract and he fails to do so, he shall pay the interest and damages from the time he should have complied without the need of any demand. Then added obligation is that yun, if the partner promises to contribute to specific determinate things, yun, preserve the property, the one that we've discussed actually in obligations and contract, deliver the fruits from the time of agreement, since partnership na is a form of contractual obligation. There's warrant against eviction and hidden defects, and then transfer ownership on delivery of the partnership, pay damages for the delay without necessity of demand, and bear the risk of loss before delivery. So, where contribution naman is industry, an industrial partner cannot engage in business for himself unless the partnership expressly permits him to do so. So, if he should fail to do so, the capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained, which we may have obtained in violation of the provision of the partnership contract, with the right to damages also. Obligations of the capitalist partner is prohibited from engaging in the business in competition with the partnership unless there is stipulation to the contrary. So otherwise all profits of such partner belong to the partnership and all losses shall be for his account. Then responsibility between partnership and partner. So the partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership. Then it shall also answer to each partner for the obligations he may have contributed in good faith in the interest of the partnership business and for the risk in consequence of its management. As to sharing the profit and loss among partners, the distribution of profits and losses shall be in conformity with the agreement, first and foremost. So, if only the share in the profits is agreed upon, the share in the losses shall be in the same proportion. So, a stipulation which excludes one or more partners from any share in the profits of or losses is void. But an industrial partner shall not be liable for losses. In the absence of stipulation, the share in profits and losses shall be proportioned to the respective capital contribution, except again the industrial partner, who shall receive a share of the profits as may be judged equitable, under, of course, the given circumstance. So, as to property rights of a partner cannot assign his right with respect to the specific partnership property for the partner's individual debts or for legal support. However, a partner can sign his share in the profits to a third person. Then, as to liability of individual partners to third persons, all partners, including the industrial partner, are liable pro rata with all the properties for contracts with third persons, provided they were entered into in the name and for the account of the partnership, then under its signature, then by persons authorized to act for partnership, and the partnership assets are already exhausted. So, as the liability of the limited partner, a limited partner is liable. Ayun nga, his liability is limited, kaya siya limited partner. But he can be liable as a general partner if whe- if he allows his surname to appear in the partnership name, and then when he takes part in the control of the business. So in those cases, He shall have all the rights and powers and be subject to all the restrictions of a general partner. Yeah, so those are the obligations of partners. So we will end our session here first. In part two, we will discuss the salient points in the revised Corporation Code of the Philippines and the important provisions that you should learn as future entrepreneurs. Thank you for listening.